My name is David Gallo. I'm the head of the AIFC Academy of Law. We are broadcasting here from Nur-Sultan, Kazakhstan, and welcome to our guest speaker, who I will introduce formally momentarily, calling in from London, as well as all of our other guests across the UK, Central Asia, and the Middle East. Welcome to everyone. We're very pleased at the Academy of Law to be offering these complimentary legal education webinars during these extraordinary times. First and foremost, we all hope that you are staying safe, staying productive and positive as we together manage through what we hope is getting to the end of this situation. The Academy of Law is part of the Astana International Financial Center, and it is dedicated to preparing lawyers for international commercial law practice. As most of you know, this is a common law, new legal jurisdiction. It was formed with the intent of attracting foreign direct investment that would create a robust capital markets context that in turn would be invested into various economic development projects, especially infrastructure projects here in Kazakhstan and across the region. So we're focused on cross-training lawyers in different systems, making sure that the lawyers of the future, and that future is with us right now, are qualified and feel comfortable and competent to operate effectively in an increasingly complex global legal ecosystem. So with that, welcome from the Academy of Law. Today's event is very unique and it's very exciting. It's the first segment in a 4-webinar series called The Room Where It Happened, Virtual Classroom with the AIFC advisory experts on the development and the application of the AIFC regime. So, first and foremost, where did this title come from, and what is this webinar series all about? What does this mean, the room where it happened, the room where what happened? Well, I have to admit, we took that phrase from a very popular Broadway musical called Hamilton, which was a fabulous artistic rendition of the early days of the formation of the US government. Well, back in the 1780s, there was no US government, and so you have to start somewhere. How did that happen? Well, what happened is some very highly trained academic minds got together, and this was a collection of individuals who were well schooled in political science, history, jurisprudence, law, and maybe most important, using today's terminology, they were pretty emotionally intelligent because they had a good sense of sociology, psychology, human behavior, and so forth. And they were faced with a challenge. The challenge was, how do you go about forming a government, a system of laws that regulates and manages human behavior? So they had to figure out, how do you frame this new system? Well, there were some great names out there, some pretty popular names: George Washington, James Madison, Thomas Jefferson, Alexander Hamilton. And again, this became a Broadway play that ended up being a global sensation. But the phrase, the room where it happened, actually came from that production of Hamilton. And the idea is that the starting point for the formation of government took a lot of thinking, reflecting, studying, proposing potential options and so forth as to how you get started. There was an outsider. There was a gentleman called Aaron Burr, and his line was, "I sure wish I was in the room where it happened, where all of this was being put together." So that's the genesis of the title. There's an analogy in the AIFC. It's a brand new legal system. It's a jurisdiction. It's a government within a government, and you have to start somewhere. So how did it all happen? It started by identifying some global experts some world-class specialists in the areas of political science, history, jurisprudence, law, sociology, psychology, and so forth. And a very high-powered, high-functioning committee was put together called the AIFC Legal Advisory Council. Well, that council was comprised of experts in their fields, primarily the fields of law and jurisprudence, and they became key stakeholders in the AIFC experiment, if you will. This was something that was new. So that group of specialists was confronted with the same challenge that the founders of the US government and any other government in the history of civilization had to confront, and that is, where do we start? What do we do? How to create this system? Well, these lectures are going to be delivered by members of the AIFC Legal Advisory Council. We call it the LAC for short. And today, the segment is called the Introduction to AIFC Law, and it will cover the early development of the AIFC law. What was the role of the LAC? What options were considered? And what's the strategic intent behind the formation of this new jurisdiction? Well, there was a gentleman who was in the room where it happened, and his name happens to be Andrew Oldland. And Andrew is with us today as our featured speaker. Andrew Oldland, that you see, is a senior partner at Mitchell Moores LLP in London. Andrew is also the head of the financial services team and the head of the regulatory team of the law firm. He has extensive experience in financial regulation and financial crimes, including anti-corruption and anti-money laundering. With that, it's my distinct privilege and honor to turn the floor over to Mr. Andrew Oldland, QC. And please, before we get started, we're going to do some Q&A at the very end of Andrew's presentation today. You'll have the ability to ask questions. Just look for the icon with the hand to raise your hand, and my colleague Almas will call on each of you individual who has a question. So please join in an interactive session later. Andrew, let me please turn the floor over to you.
Yes, thank you very much, David. Good morning, everybody, or good afternoon to those of you in Kazakhstan or the region. It's a great pleasure to deliver the first of these talks for the Academy of Law. Now, lawyers love disclaimers, don't they? And I'm afraid this lecture is no exception. This is an introduction to AIFC law, and in the time frame available to me, it is necessarily quite high level. I will not be troubling you with the detail of the legislation, apart from a little excursion into the constitutional statute. This lecture is about the framework, the structure of AIFC law and how the structure works primarily. And finally, I cannot and do not speak for any of the AIFC bodies, such as the court, the AIFC authority, or ABSA. So that's the disclaimer. So let's get going with the talk and on to the first of my slides. The LAC was set up in order to deliver strategic legal advice to the AIFC and to the governor in particular. And its purpose was to review appropriate legislation, and its chairman is Michael Blair, Queen's Counsel, and there's myself in addition to Michael and 6 other members. We are all in private practice. We are English law qualified. We have experience of international finance and of international financial centres. Now we're going to start by having a quick look with this slide at the legislative hierarchy that applies for the AIFC. At the top, of course, is the Constitution of the Republic of Kazakhstan, which required amendment in order for the AIFC to come into existence. And that is Article 2, subsection 3, with which many of you will be familiar. Then the key document is the Constitutional Statute, which was passed in December of 2015. And sitting below that are decrees or resolutions of the President, and types of decrees and resolutions you can see set out there. Below resolutions of the President, you have resolutions of the AIFC Management Council, which are beneath the President, the highest level of lawmaking within the AIFC. And you can see set out there the types of matter that the Management Council deals with, including the courts. And just skipping up to the decree resolution of the President, it was thought, of course, important that the President should appoint directly members of the judiciary of the AIFC in order to ensure their independence, which is what has happened. Beneath the resolutions of the Management Council, you see regulations adopted by the AIFC Governor. Now, this is the key part, or part of the key parts of the work that we on the LAC carried out. And the legislation broadly falls into two types. One is the general legal framework regulations, and the other are a set of bespoke financial service regulations. And I'll come on to both of those in a minute. And then beneath the regulations adopted by the Governor in the hierarchy are various rules made under those regulations by, for example, the Financial Regulator, AFSA, or the AIFC Authority. And so you will then have those rules or financial services rule books. So that is, in a snapshot, a simplified version of the legislative hierarchy that applies. So let's just have a look, and this is the only piece of legislation we're going to look at the Constitutional Statute. The Constitutional Statute in Article 4 sets out what law applies in the AIFC. Subsection 1, which is not on the slide, is the Constitutional Statute. And subsection 2, which is set up, is the AIFC Acts, which are not inconsistent with this Constitutional Statute, and which may be based on the principles, legislation and precedents of the laws of England and Wales, and the standards of leading global financial centres. There is a clear steer in that provision of the Constitutional Statute towards English law and English common law. Why is that? The reason why, I hope, is relatively clear. London, for many years, has been one of the great financial centres of the world, and supporting London's operation as a financial centre has been English law, which is and has been deemed to be particularly suitable for the world of international finance for a number of reasons. First of all, its familiarity, people know it. Secondly, its flexibility. The common law system allows a degree of flexibility which is of particular use when there are all the rapid advances that we see in the international financial world. And there is also the high reputation of the English judiciary, which has certainly helped cement English law at the centre of providing a framework, a legislative framework for finance. Articles 13.5 and 13.6 of the statute give more of a steer about the operation of the common law. I'm not going to talk too much about that now because a colleague of mine, Simon Cox, will be describing to you how common law works and the similarities and differences between the common law and the civil law systems. But those articles set out on the slide clearly give a steer towards the use of precedents, in other words, final judgments of the court, in other words, the AIFC court, and of courts in other common law jurisdictions. So where things aren't clear from the legislation, or where the court needs some sort of guidance, they can take into account other judgments in a what's called a persuasive manner rather than a binding manner. Right. There is also a steer within that provision that we looked at a moment ago towards achieving international best practice. And the centre is a commercial centre primarily. It does not deal with aspects of criminal law or administrative law. And then subsection 3 is very important, and the acting law of Kazakhstan, which applies in part to matters not governed by this constitutional statute and AIFC acts. The default position is the law of Kazakhstan. This is very important. The AIFC legislative process is often described as a sandwich, with the constitution of Kazakhstan at the top, and at the bottom is the law of Kazakhstan. In the middle is AIFC law, and to the extent, as is set out in subsection 3, that matters are not covered by AIFC legislation and laws, the default position is the law of Kazakhstan. And that, as far as I'm aware, is unique when one comes to look at international financial centres. It has some challenges, which is that you may, in certain circumstances, need to access both AIFC legal advice and advice on the law of the Republic of Kazakhstan in order to solve an issue or problem. But one of the potential advantages of it is that the financial centre has perhaps a closer connection with the mother country, namely the Republic of Kazakhstan, than perhaps some other financial centres. Right. So what were our tasks? So our first task on the LAC was to identify a suitable model for the general legal framework. The GLF was intended to support a bespoke set of financial regulations, and we had, in order to come to conclusions, we had to use comparators with the UK, DIFC in Dubai, and the ADGM in Abu Dhabi. The DIFC regime was selected, and we also included aspects of the UK and the ADGM regimes as the model. And the reason the DIFC was selected was for its relative simplicity and the fact that as a freestanding international financial centre within a mother nation, its track record, it has been around for much longer than the other international financial centres. It is, of course, a starting point from which AIFC law will and can develop. So there's a good deal of legislation that we'll come on to in a second that has been introduced, but you can expect two things. First of all, there will be some more legislation, and secondly, that the legislation that's in place will be reviewed on an ongoing basis. So our second task was to review and comment on the work of the draftsman. So on the LAC, we did not in fact draft the legislation. It was provided to us, we reviewed it, we suggested amendments, which would then go back to the draftsman, and then ultimately we hoped that we got to a position where we all agreed and we would then make recommendations for the adoption of that legislation to the governor and to other AIFC bodies, primarily the authority and AVSA. Other tasks included assisting with the preparation of explanatory documentation, including FAQs, frequently asked questions, and reviewing the legislation, as I said, on an ongoing basis for clarity and consistency. There are also a number of codes and guidance that's being introduced to the centre, and on the LAC we review those or are involved in drawing up some of those codes. So let's just have a look now at the legislation contained within the general legal framework. What it is, first of all, is a selection of different pieces of legislation. In the UK, we call them acts. It's not a unified code. So set out there on that screen, you have the current regulations, pieces of legislation that apply as part of the general legal framework within the AIFC. Top left is regulations on AIFC acts. In a nutshell, that sets out how you interpret the legislation and how the legislation interacts with itself. And then across the top row, you'll see Companies Acts, Special Purpose, Company Rules, Partnership, and so on and so forth. Moving into the contract regulations, employment, regulations on obligations. In English law, we call that tort, non-contractual liabilities that can arise, and then a series of further pieces of legislation designed to support the financial regulations that we'll look at in a moment. They include data protection, personal property regs, foundations regulations, trust regulations, all intended to assist the operation of a financial centre. And the reason the two boxes on the bottom right are circled in red is that they relate to the court and the arbitration centre. We, the LAC, did not review those two sets of regulations. They were dealt with primarily by the court and arbitration centre itself. So much of the legislation of the GLF is similar to that of the DIFC. What it does is it sets out in a simplified version English law. What happened in the DIFC was that they took English law and they put it into a form of simplified legislation to make it more user-friendly, and that is why we felt on the LAC that was the most appropriate model rather than attempting to adopt English law as a whole into the AIFC. Jurisprudence of other common law financial centres will be persuasive, but it's a matter for the court, of course, but particularly English law we would suggest. But again, unlike the DIFC, the law of the Republic of Kazakhstan is the default position. Again, that is an important distinction from the other international financial centres that exist. The default position in Dubai, if it's not covered by legislation, is English law. In the ADGM in Abu Dhabi, they virtually, with a few exceptions, largely imports English law as a body of law into that particular financial centre. The AIFC is significantly different, therefore, in that regard. Right, let's just have a look at some of the financial regulations. The financial regulator, the key financial regulator, is the Astana Financial Services Authority, ABSA, and AIX, Astana International Exchange, regulates aspects of the operation of the capital markets. The key overarching piece of legislation is the Financial Services Framework legislations. That is equivalent to what's called FSMA, the Financial Services and Markets Act in the UK, but it is a great deal simpler and is intended to be easily understood and applied. So with that at its core, a number of financial services rules were added which refer back to the framework regulations. And let's just have a look at those. And you can see a variety of rules that sit under those framework regulations. There are the rules required to set up and run a stock exchange, the authorized market institution rules, the market rules. There are rules relating to banking, to insurance, Islamic finance, AML, anti-money laundering, fintech, and IPO listings, and also to the functioning of the auditor functions and various prudential rules. So bespoke rules that are designed specifically for the AIFC. And you'll see a focus on the pillars of the AIFC when you look at those rules. There's capital markets, asset management, Islamic finance, fintech, private banking contained within those rulebooks. Right. So the regulation of financial services based on international best practice with an emphasis on simplicity, certainly initially. And as the centre develops, these rules and rulebooks may well become more complex and more comprehensive. In deciding on what the best models were, DIFC, the UK, Malaysia, Guernsey, Australia, a number of jurisdictions were considered. The general rules, Schedule 1, sets out the current list of regulated activities within the AIFC. And that is a list that over time has gradually been expanding as more and more regulated activities are happening within the AIFC. So that's always a good starting point for you to have an eye on as to whether or not particular activities in question are going to require authorization by the regulator. You will also need to look at the AIX rules if you're considering capital markets activity. The listing rules are covered by AIX rather than by ABSA. And AIX is a self-regulating exchange, different, for example, from the London Stock Exchange, which is largely regulated by the Financial Conduct Authority. So let's move on now to some other concepts of AIFC law. The Presidential Decree number 614 from December 2017 set out the territory within Nur Sultan of the AIFC. You will see that it encompasses obviously the AIFC site, the old Expo Centre, but it also encompasses a good part of downtown Nur Sultan, which contains many businesses that have been operating there for a number of years. So what is the nature of the AIFC? And this is of some importance. When one looks at some of the other international financial centres, and if you look at the DIFC in particular, it is defined by its territory. It is perhaps best described as an enclave. In order to be a member of the DIFC, you have to be within those strict territorial limits. The AIFC doesn't have those restrictions, and I should add to that anyone operating within that territory in the DIFC is a part of the DIFC, has to be a member of it. The AIFC is closer to a club than it is to an enclave. That is to say, it's a bit like a golf club, perhaps. You apply to become a member. If you are a member of it, you have to abide by its rules, but you're not restricted by the territory of the golf club. You can still be a member of the golf club from a distance. So it is more analogous to a club. You are required to have a registered address within the territory that I've shown you on that previous diagram, and some physical presence within the AIFC is required, but the requirements of physical presence are not particularly high or onerous. So I often describe it as a club with a residence requirement. So it's neither completely a club, certainly not an enclave, but it's much closer to a club, but it does have a residence requirement. And of course it follows from the map that I've shown you that not every entity operating within the territory of the AIFC will be a centre participant, and far from it. As you know, most will continue to operate their businesses, as they have been for many, many years, from the centre of Nur Sultan, and they will be subject, obviously, to the laws of the Republic of Kazakhstan. So let's just have a look at what it means to be a participant. Article 1.5 of the Constitutional Statute sets out for you there how it is that you can become a participant, either by registration or recognition. Recognition will be important. Certain types of foreign recognised entities may operate within the AIFC without becoming participants. And the AFSA also holds the company registrar function, although they are divided within AFSA to give it a degree of independence. So just looking at licensed AIFC participants, those are those participants requiring authorization of some sort, who will be regulated within the AIFC. You have on the left authorized firms carrying out regulated activities, and in order to decide whether or not you fall within those activities, you have to look at GEN, Schedule 1, and there you have set out some examples of the types of activity covered by GEN. There are others now that include insurance and so on and so forth. So you look at GEN Schedule 1 to work out if you need authorization. If you do, obviously you have to apply to AFSA in order to be able to carry out those activities. In the middle, you've got authorized market institutions, to do with the operation of the stock exchange. They're set out in general Schedule 4, which includes the exchange itself, clearing houses, e-trading and crowdfunding. And then on the right, you have ancillary service providers who are considered very important players in the operation of an international financial centre: legal services, audit services, accountancy services, consulting, credit rating, and so on and so forth. And that's set out in Gen Schedule 2. That gives you an idea of licensed or regulated participants within the AIFC. Now, another interesting concept I'm just going to touch upon very briefly, which may be discussed in more detail next time, is conducting business in or from the AIFC. AIFC participants can generally operate in or from the AIFC, but it may be sector and entity specific. It is, after all, a financial centre primarily. It's not a centre for the extractive industries, it's a financial centre, although there may be elements of the corporate structure within the extractive industries that could find it attractive to register within the AIFC. It allows its participants to carry on business in other jurisdictions and in Greater Kazakhstan, so you're not prohibited as a participant from carrying out business outside of the territory that you saw on that map. But the extent to which you will be able to do that using your AIFC authorization only is going to depend. It's going to depend on what you're doing and the extent to which you are doing it. But you could be based within the AIFC, and you could receive customers from, say, the Republic of Kazakhstan to conduct business with you. Whether or not you will also require authorization from the National Bank of Kazakhstan, for example, is going to depend very much on what you are doing. And factors likely to be important in this regard could include the extent of the AIFC's participants' activities and presence in the other jurisdiction. For example, if you set up and you're running an office in Almaty, the chances are that you would fall to be regulated through the National Bank regime. And whether the business is booked in the AIFC and governed by AIFC law. So that's another factor. So generally speaking, if you don't have a physical presence outside the AIFC, the business is done through the AIFC, the contacts are coming to you in the AIFC, it may well be that you can rely on your AIFC authorization alone and you don't require dual authorization. But again, that's an area that will develop, I'm quite sure, and I'm sure there will be moves to coordinate with local and international regulators in that regard. So that is a canter through AIFC law, an introduction to it. I hope it's set the scene for you. We've got roughly a quarter of an hour to go. So what I'm going to do now is hand over to David again, who will marshal any questions that you have and pitch them at me.
Andrew, with your permission, me also will assist you on this moderation of the Q&A session.
Of course.
It's me, Almas. Dear guests, good afternoon. So once again, if you want to ask your issue, you can tap on the raising hand button at the right bottom of your screen. Then I will activate your mic, and after introducing yourself, you can ask your issue. So please feel free. Oh, I see. I get him. So I get him. I have turned on your mic.
Hello.
Hello.
Hello. My name is Agirim. I work as an associate at AIFC. I have a question concerning the default position of the Kazakhstan law. Actually, this question is one of the frequently asked issues among our current participants. So my question is, assuming that there is an AIFC Act regulating corporate matters in the AIFC, but this act is silent on specific matters. In this situation, would Kazakhstan law apply to these particular matters?
Yes, thank you. That's a very good question, because it says within the constitutional statute in part, doesn't it? The position is, certainly as we understand it, it will ultimately be a question maybe for the courts to determine, but the position is that provided there is a piece of AIFC legislation that covers the topic concerned, it will be AIFC law that applies rather than the law of the Republic of Kazakhstan. So if I were to give you an example on, say, data protection, there is data protection legislation, as we looked at when we looked at the GLF, that is in force and applies within the AIFC. I don't know off the top of my head whether it is more comprehensive or less comprehensive than the data protection provisions within the law of the Republic of Kazakhstan. But let's say it is less comprehensive, for example, and that the data protection regulations of the law of Kazakhstan covered areas not covered by the AIFC data protection law, they still would not apply. It would be the legislation relating to data protection within the AIFC that would apply. So as long as there is some legislation covering the topic concerned within the AIFC, it is that legislation and that legislation alone that would apply.
Okay, thank you very much.
You're
That was clear
welcome.
for me. Thank you.
So thank you again for your issue. So any other issues?
Yes, I have a question, Andrew. It's David. Andrew, could you elucidate further this concept that English common law precedent, so cases and decisions heard and rendered by English courts, would be binding precedent? I suppose to the same extent they would be binding if the case had happened in England. And then the ability of litigants to rely on other laws outside of the AIFC or English and Wales jurisdictions as the basis of persuasive authority. Could you just kind of elucidate that a bit in terms of what the parameters might be around persuasive versus mandatory precedent?
Yes, well, again, subject to how the courts interpret the constitutional statute, my understanding is that broadly it will mirror the system that we have in England and Wales, which is that if one of our final courts has interpreted a piece of legislation in a particular way, particularly if it's the Court of Appeal within the AIFC, that is likely to be binding on other court decisions in the future within the AIFC. However, what it also clearly says within the constitutional statute is that the court may had regard to the courts, the final courts of other common law jurisdictions. So that, to me, means persuasive, is that the you can use, if there is no AIFC Court of Appeal decision, for example, decisions from the UK or from Australia or the DIFC, in order to attempt to persuade the court of your position if it assists you. So persuasive, I would have thought, will be the primary starting point, but not binding.
Yep. And Andrew, do the AIFC courts also have the ability to create their own common law where over time, maybe based on local customs or practices or social policy or government policy, or is there an opportunity for the AIFC courts to start to diverge in some cases from English law precedent?
Yes, I very much believe so. And I think that is one of the great advantages of a common law system, is that it can tailor itself relatively easily to local circumstances. And I believe that will happen. One of the words used in the constitutional statute was the principles of the common law of England and Wales. And one of those principles is, in my view, the ability to build up a body of law, a body of precedent that can adapt the laws of the centre to local circumstances. And I have to be completely candid with you. We on the LAC have done our very best in a relatively short period of time to consider a vast body of legislation. And we will review it as time goes on and see if we can tweak it and improve it. But there will be gaps, there will be issues of interpretation, I'm quite sure, that will need to be resolved by the courts. And so that body of precedent, I think, will be extremely useful in assisting not only with interpretation, but also with tailoring the legislative regime to fit the particular circumstances that apply to the AIFC.
Thank you for that. I suppose that's the beauty. One of the benefits of a common law system is while it looks to established precedent in major international jurisdiction like those of England and Wales, it also has the ability organically to evolve, to be fit for purpose, if you will, in the local environment. And I suppose that's the beauty, that's the best of all worlds, where ultimately, if we could project 40 years, 50 years hence, we might see a body of common law that has evolved here at the AIFC that has truly become local in its application and fairness, while maintaining those principles that had been developed internationally over the course of hundreds of years in England and Wales. So I suppose we're in the midst of the genesis of what could be a very exciting jurisprudential journey as the AIFC legal system evolves over time.
Yes, I agree with that, but there is another element that I mentioned in my talk that makes it even more interesting, which is that the default position where matters are not covered by AIFC laws is the law of the Republic of Kazakhstan. And I think what will be fascinating to see will be that where you get those instances that occur is the extent to which interpretation of the law of the Republic of Kazakhstan either enters into or doesn't enter into the set of common law precedents of the AIFC. We will wait and see what happens there.
That could be really fascinating. You have the cusp of new common law developing. Where does that end, and where does the Kazakh national law begin? I suppose that sort of gray area will make for some really interesting jurisprudential development.
Yes, absolutely.
Great stuff. From the audience, are there any other questions? Please ask them now. Is there anything on your mind relative to how these systems operate and work together? We have the privilege of being with Andrew Oldland, who is in the room where it happened. So this is a great opportunity. Anybody else? Any questions?
Yep, Camila, I see.
Hello, everyone. My name is Camila Majenova, and I have a question. Due to this pandemic situation, I'm just interested to know, will the AIFC law is going to be changed, taking into account the COVID-19 situation?
Well, I don't think the law is going to be changed. I certainly haven't heard of any specific pieces of legislation that are going to be introduced to deal with it. I do know that recently there was a lecture, or there have been a series of lectures organised by the court covering traditional issues such as force majeure, frustration, and the like, which seems to me to be the main area where the COVID-19 outbreak is likely to have some relevance. So I'm not aware of any specific legislation that's going to be introduced that addresses that. I'm not sure, strictly speaking, that where the AIFC is in its progress at the moment, that it's necessary.
Okay, I see. Thank you very much.
You're welcome.
Thank you, Camila. Any other questions? So do not hesitate to ask them here. So after the event, we are receiving several questions, so it's better to ask them here. And in case you won't be able to ask here, you can then send to our email. We'll be happy to answer. Girim, I see.
Hello. Yes, good afternoon, sir. My name is Girim. I'm from Emirates Legal. It is a law firm based in Dubai and the AIFC. So I have one question. Recently, the president of Kazakhstan instructed to provide access to Kazakhstani entrepreneurs to use the AIFC law and its dispute resolution institutions like the AIFC court and international arbitration centers. So my question is, can Kazakhstani entrepreneurs use the AIFC law or dispute resolution institutions today? Thank you.
The short answer to your question is yes, they can. The key to it is that if you are in a dispute, all parties must agree to submit themselves to the AIFC dispute resolution mechanisms, be it the court or the arbitration centre. You can either agree that on an ad hoc basis if you're already in a dispute, or it can be provided for in your contract. And when you're putting together your contract, you obviously choose the law that's going to govern the contract, but usually also you set out how disputes are going to be resolved. So it seems to me that that was an encouragement from the president for entrepreneurs to consider using both of those. One is AIFC law as the governing law for the contractual relationship, and also were the parties to fall into dispute, an agreement that it could be resolved through the AIFC dispute mechanisms, even if it doesn't have any direct factual connection with the AIFC itself. So you can certainly opt into dispute resolution within the AIFC, provided both parties to the dispute, or all parties to the dispute, agree.
Yeah, Andrew, that's an excellent point. If you have a complex commercial cross-border contract and the parties are from different countries, even if their commercial transaction has nothing to do with the AIFC or with Kazakhstan, to Andrew's point, the AIFC law can be chosen to govern the rights and obligations of the parties under that contract. And the AIFC dispute resolution institutions, the courts and the arbitration center, can be chosen as the forum for resolving any disputes that may arise. Well, that's a tremendous sense of comfort for contracting parties. Again, they may be from different countries, different jurisdictions. Neither one may want to agree to submit to the laws of the other country or to the dispute resolution processes of the other country. There might be some natural skepticism on whether fairness can be relied upon and justice can be served. So this is a way for contracting parties in international commercial transactions to have that sense of confidence that their contracts will be enforced according to their terms and that justice would be administered swiftly, efficiently, and fairly in the event of a dispute. It's a major benefit. You don't even need to register your company in the AIFC to do this.
Yes, I agree.
Yeah, good. Are there any other questions from the audience? Almas, just let us know if in the next 30 seconds or so if there are any other questions.
I guess we have no questions yet. So if audience will have questions, please feel free to send us via email. We'll be happy to answer. So,
excellent.
Yes.
Okay, with that, I would like to invite, or I'd like to congratulate and express our appreciation to Mr. Andrew Oldland, QC, for his fabulous overview of the early days of the AIFC development, the legal system evolution, and why decisions were made and how it all works. So thank you so much, Andrew. And many thanks to all of our participants. Remember, this was the first lecture in a series of 4 webinars that will be hosted by those who were in the room where it happened, members of the LAC. Okay, thank you so much to everybody. Have a great day.
Thank you.